Donald Trump submits his brief to the Supreme Court of these United States. He is petitioning the court to undo what Colorado has done, which is ordered him removed from the ballots pending further review from SCOTUS. We're going to go through the full petition. There has been a lot of activity on this case because everybody is skidding in their briefs, amicus briefs from state secretaries of states, attorneys generals are submitting theirs. We've got House of Representatives that have submitted theirs. Senators are sending theirs in. We've read from Edwin Meese, former AG for Ronald Reagan, sent his in, and even Bill Barr sent his one in, supporting Donald Trump, saying Trump needs to remain on the ballot. So Supreme Court is going to be getting into this very soon, but this is Donald Trump's brief himself. We're going to hear what Crazy Eyes Griswold over from Colorado, the Secretary of State over there, what she has to say about this in response. And then in this segment, we'll wrap it up with Donald Trump's reaction, saying, how is the court going to rule? He'll weigh in. So first, let's go right over to the brief itself and dig into it. In the Supreme Court of the United States, the case is Donald Trump as the petitioner. He is against Norma Anderson and the respondents. These are the litigants from Colorado who filed their private claim to remove Trump, saying he was guilty of an insurrection and he was disqualified under the 14th. So writing for Trump, you see Harmeet Dillon's law group, shout out to her, and the rest of the co-counsel all submitting their brief. They're asking the Supreme Court, they're saying, all right, SCOTUS, this is a pretty important situation here. We have an election coming up any minute. The Supreme Court of Colorado, they held that Trump is disqualified from holding the office of the presidency because, one, he engaged in insurrection, and that he did so after taking an oath as an officer, and that oath was to support the Constitution. Now, the state Supreme Court, 4 Democrats, ruled that the Colorado Secretary of State, Crazy Eyes Griswold, should not list Trump's name on the 2024 ballot. And then she comes out and lectures us, saying this is all done in the sake of democracy. So the question here for you, SCOTUS, is very simple. Did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 primary presidential ballot? Yes or no? Now, we know all the parties to the proceedings, Crazy Eyes Griswold, we got Trump, we got all the Anderson petitioners, the litigants, and we'll see that a lot of these arguments are the same things we've already discussed, but this is from the perspective of Donald Trump. And this is a historic case. I really do think that if SCOTUS, for whatever reason, allows the states individually, allows Colorado to just unilaterally on their own say the 14th Amendment is self-executing, boot him off the ballot, this country's in for a very, very rocky election and beyond, because that is going to allow this domino effect that's already in motion to continue to occur. In states like Arizona, where I'm at, will absolutely be next. We'll see lawsuits filed and they'll say, well, Colorado did it, and they're like right over there. So why don't you do it too? And Arizona's a swing state. Maybe Colorado is going to go blue anyways. I'm not so sure about that, but you can see what's going to happen. Eventually, one state is going to matter, and it's going to cause a fissure and a fracture that is literally disenfranchising millions of voters if it's allowed to stand. So this is what Donald Trump says. All right, SCOTUS. On December 19th, the Colorado Supreme Court ordered President Donald Trump, the leading Republican candidate for president, removed from the presidential ballot based on a dubious interpretation of the 14th. And now this domino effect is underway. 30 states are now trying to remove Trump from the primary in the general election based on similar rationales. And yet it is, quote, fundamental principle of our democracy embodied in the Constitution that, quote, the people should choose whom they please to govern them. Saying this court, SCOTUS, should put a swift and decisive end to these ballot disqualification efforts. These threaten to disenfranchise tens of millions of Americans, and which promises to unleash chaos and bedlam if other state courts and other state officials follow Colorado's lead and exclude the likely Republican presidential nominee for and from their ballots. Saying the court should reverse the Colorado decision. Why? Well, because Trump is not even subject to Section 3, as Trump is not an officer. The president is not an officer of the United States. And even if Trump were subject to Section 3, even if you say it did say the president fit under there, like a sub-bullet point, well, he didn't engage in anything that would ever qualify as an insurrection. And so the court should reverse on these grounds and end these unconstitutional disqualification efforts once and for all. Writing, there are additional grounds for reversing the Colorado Supreme Court. Now, the state courts should have regarded congressional enforcement legislation as the exclusive means of enforcing Section 3. In other words, Congress should have done something. We hear this back and forth about whether Section 3 is self-executing or not. In other words, does Congress have to do something? Does there need to be some legislation in order to enact that? Or can Crazy Eyes Griswold and Shenna Bellows just say, well, you know, they were on a Zoom call with the rest of their Avengers, the Secretary Avenger team, and they just decide to, you know, kind of copy each other's homework? Or does Congress have to do something, you know, like impeach and convict someone, or indict and convict someone somewhere else? So in addition, Section 3 cannot be used to deny Trump or anyone else access to the ballot. Why? As Section 3 prohibits individuals only from holding office, not from seeking or winning election to office. Huh, that's a pretty interesting little nuance there. Well, Trump's not holding office right now. He's just running. And maybe if he wins before he's seated, that's the appropriate time to challenge this. And then Congress could overcome that removal by the 2/3 vote pursuant to the operation of the statute. So we'll get into that. Now, finally, they say Colorado Supreme Court ruling, it violates the electors clause as well, because nothing in Colorado's election code allows the state judiciary to order the secretary to remove the candidate from the ballot. Now, the court has jurisdiction. We know who the parties are, Trump and everyone else. Saying here, Your Honors, at the Supreme Court, over the last few months, more than 60 lawsuits funded by who knows who, or administrative challenges have been filed in an effort to keep Trump from appearing on the ballots. Now, the theory behind these lawsuits is that Trump is disqualified under the 14th. Why? January 6th insurrection. Now, many courts have rejected these claims for varying reasons until Colorado showed up on December 19th and said, "Merry Christmas, America!" And they ordered Colorado Secretary Griswold, Crazy Eyes, to exclude Trump from the ballot. And she is rabidly anti-Trump. If you follow her on X, it's wild. Every day she's got a new anti-Trump post. And she's going to be the person who's running the elections as the Secretary of State. So why would she be trusted to do anything, without bias if she's clearly rabidly anti-Trump? Anyways, so the respondents in this case include 6 individuals. These are the Anderson litigants. Trump is appealing this. They responded. They sued Colorado and Griswold. And we saw this same pattern in 2020. So I am, ringing the alarm bells just like we did in 2020. This is what happened, okay? Friendly groups sued friendly secretaries of states, and they colluded under COVID to change the rules. They went to friendly judges. Nobody knew what was going on because we were all like, are we going to die tomorrow or what? But this is what they were. Oh, COVID's changing. So signature, collection, ballot drop, waive this, waive that. It was Bedlam. And they did that because friendlies sued friendlies, like playing like, oh no, don't sue us. Oh no. And then they would just agree to each other and go into these courts, and the courts would rubber stamp it. It would rig the whole election. We covered, I don't know how many videos we did here. They're all there. So the Anderson litigants, they sued under Colorado revised statutes. And then they said, Colorado's like, well, I have it. You're right. Wow. Thanks for bringing it to my attention, says Griswold. You're right. I do have an obligation. And so I do need to do something about this. Now, nothing in Colorado's election code actually does require her to do this. She says, well, thank you for suing me. I guess I have a constitutional duty to analyze Trump's insurrection. And lo and behold, she found insurrection. Just happened to coincide with her political biases. But yeah, I'm sure she did her due diligence. So now she says, I have no choice. And then we have this litigation that happens. Trump is ultimately removed. But Trump's people are saying she had no basis for doing this. There's nothing that requires her to do this. She just shoved herself into this process because she's got TDS. Instead, the Colorado statutes actually requires the presidential primary candidate to submit a notice of intent. That form, we did this, and we got the form right from her website. And all it says is this right here. This is the form. You can see this is what Trump's people filled out. Here are the qualifications for office. You must check each box to confirm that you meet all the qualifications. Trump, yeah, 35 years of age, got that, no problem. Resident of the United States for 14 years, bingo, got that one. Natural born citizen, bingo, got that one. Now that's it. The statement of intent form also requires candidates to sign an affirmation that they meet all the qualifications as prescribed by law. That's it. Here it is. I intend to run for the office stated above, and I solemnly affirm that I meet all qualifications for the office prescribed by law. That's it. That's your job. So Trump says, beautiful, got that right there. Donald Trump signs that, boom, and then that's the end of the question. That's the end of the conversation, says Trump's people. Now, a signature line appears below that, along with an unfilled notarial certificate. Now, Colorado law, it imposes no duty on the secretary to actually verify or to second guess any of this, or to exclude candidates from the ballot if the secretary believes or disagrees with that. You don't get to decide, well. So Anderson litigants nonetheless insist that she does have a mandatory duty, the people who sued. You can't just stand by, even though there's nothing on your form that says insurrection. There's no insurrection box. I promise I didn't commit an insurrection as governed by fake insurrection committees governed by Liz Cheney and Benny Thompson. There's not that form on here. Okay, so Trump didn't have to click anything. So as we continue, they say here the 14th Amendment is not where they derive this. They also claim that any decision to put Trump on the ballot would violate the Constitution. It would be a breach of your duty, right? They actually were suing her like, listen, Jenna, if you don't actually throw him off, you're the bad person. You're a co-conspirator, essentially. They sued her and said, well, now she's just sitting at her office. She's like, oh, this is a great lawsuit. Throw Trump off the ballot? Perfect. What do I have to do to fake like I'm defending this? So then the Anderson litigants, they sued. They filed it September 6, 2023. The district court did not hold a hearing within 5 days. So procedurally, they goofed. Law says, well, if there's an election litigation situation, you got to have a hearing quick. Timelines are compressed. Law law says no later than 5 days after the challenge is filed, the district court shall hear the challenge and assess the validities. Not may, not like a suggestion. It's like shall be done. So schedule it now, go. That's the law. Instead, the district court held a status conference on September 18th after the statutory deadline, and the 5-day hearing began 54 days after the fact, not 5 days after the challenge was filed. So they're way late. Now, the district court denied a bunch of motions to dismiss this case. They also denied Trump basic discovery tools, like the opportunity to depose expert witnesses, like the opportunity to subpoena and compel the production of documents, like the opportunity to get timely disclosure so they could actually, read it. And the district court's improvised yet still compressed time frame gave Trump only 10 days to identify his rebuttal witnesses and 18 days to identify his rebuttal experts. Then we had this fake 5-day scam hearing that we listened to. The court did not issue findings and facts within 48 hours, even though the law says that. She waited. Instead, the district court held closing arguments 12 days after the fact, and then they issued findings and other conclusions of law. Now, their findings of fact rely heavily on the final report by the illegally constituted January 6th Select Committee, and that's by their own standards, okay? H.R. 503 was the governing document, and it is not complied with Liz Cheney. There were supposed to be 5 Republicans on there. There were not. There were 2 by their own document, and they are illegal pursuant to their own governing records. So the district court also relied on testimony from Peter Simi. But backing up, by the way, the J6 stuff, hearsay. It was all a legislative book report that was not subject to really any cross-examination at all. There wasn't any cross-examination. There was not even any opposing witnesses presented. There was not even an opposing narrative. It was literally a big, long book report, like with PowerPoints, reading from their slides. It was ridiculous. And a lot of it's fake, by the way. Clavicle Girl, for example, is just one example of the fake testimony that's not even true, which would have come out if there was cross-examination and due process, but there wasn't. So they admitted it anyway. She's like, close enough. Liz Cheney's a congressperson. Not anymore, because she lost big time, loser. So here, the district court also relied on this guy, Peter Simi. He's a sociology professor, and now he's, I guess, responsible for American elections. Now, he said Donald Trump speaks like far-right political extremists, and so they listened to him because he has a history with political extremists. So the district court wrote, Trump's encouragement and promotion and the fight, it wasn't metaphorical. He was referring to literal violence. He was calling people to violence. Now, this guy, this sociology professor, relied exclusively on public speeches. He conducted no research interviews. He didn't do any field work. He disclaimed any opinion on Trump's state of mind. He has no idea. But the district court still used this bizarre testimony to support its factual finding. This guy's like, well, I watched a lot of Trump videos on the internet. So what are you doing here? To talk about your opinion of Trump? Thanks. Judge is like, well, this is brilliant testimony. Love those videos. Great YouTube channels. So for its conclusions of law, the district court held that the Colorado election code does not allow the Secretary of State to assess the candidate's eligibility. The lower level court, Judge Sarah Wallace, was even not crazy enough to do this, despite her hair. But it nonetheless held this does give courts the authority because it requires district courts to hear the challenges. So she actually did hear the case. We heard that. Now, the district court did go on to hold that Trump engaged in an insurrection. We're familiar with that. But they said that it doesn't apply to the presidency. It said the presidency is not an office for the purposes of this. Okay, so that's Sarah Wallace. Got it. Then it went up to the state Supreme Court. So both Anderson and Trump sought review at the next level. Why? Trump said, first of all, yes, I know it doesn't apply to me under the 14th Amendment, but secondly, I'm also not somebody who engaged in insurrection in the first place, because she found that there was an insurrection, but it didn't apply to him. He's saying, no. First of all, it doesn't apply to me, but there wasn't an insurrection, so you were wrong there. So they both said she was wrong, but for different reasons. Now, the Colorado Supreme Court ultimately found as they found. They say, having concluded that the Anderson litigants could proceed, the state Supreme Court then considered the merits. So they bypassed all of the procedural stuff. Well, that's delayed, whatever. They said, no. Trump had plenty of due process. The fact that he couldn't subpoena evidence or that he didn't have time to actually read documents or things like that doesn't matter. He got enough due process. The fact that it was hearsay evidence from Liz Cheney, no, it's okay. They don't care. So they ultimately reversed and they found that it does apply to Trump. And so now let's see their argument. A lot of procedural history there that I think maybe could have been condensed a bit, but here we are. They say the court should reverse now because President Trump is not subject to Section 3. The president is not an officer of the United States as that term is used in the Constitution, lowercase o. President Trump also never swore an oath before he became president that could either trigger that. And number two, the court should also reverse because Trump did not engage in an insurrection. The Colorado Supreme Court tried to impute the conduct of others onto Trump, but the litigants needed to show that Trump's own conduct, his own conduct, was an insurrection on its own. And they can't make a showing because Trump never participated in any of the conduct. In fact, the opposite is true. Trump sat around calling for peace and patriotism patriotism, telling him to go in peace. But the court should follow the rationale, they say, of the district court's dissent and allow judicial and judiciary enforcement only through congressional implementation of legislation like a different section of the U.S. Code. Says Congress should be the people who decide, not the lower level court. Saying the Colorado Supreme Court also violates this Supreme Court case called Thornton. That case prohibits states from prescribing their own qualifications for the presidency. You don't get to decide that this person's eligible or not, because we have a federal constitution that encompasses the nation. The Constitution requires, they say, that the president qualify that under Section 3 only during the time that he holds the office. But Colorado Supreme Court is demanding that Trump is disqualified at the time the primary and the general elections occur, which is during the run. And 5, they say the Colorado Supreme Court ruling also violates the Electors Clause and that the judiciary should not be allowed to remove them. So let's get into this analysis. First, that Trump is not an officer of these United States. They say, all right, Supreme Court, Section 3 says this. It only applies to those who have previously taken an oath as a member of Congress or as an officer, lowercase, of the United States, or as a member of any state legislature, or as an executive of any state to support the Constitution of these United States. Now, it's undisputed that Trump never took an oath as a member of Congress. Okay, so that one's gone. So member of Congress, so that's deleted, get rid of that. He never took an oath as a member as a state legislator. Okay, get rid of that one. He also was not a state executive or a judicial officer. So no state executive. So that's gone too. He was not a member of any state. Okay, so that's gone. So it would have to be just this one, an officer of the United States. That's it. Now, the Constitution's text and structure makes clear the president is not an officer of the United States. Why? The phrase officer of the United States appears in 3 constitutional provisions outside of the 14th. The Appointments Clause says that the president shall appoint ambassadors and all other officers. Ambassadors, public ministers, consuls, justices, and all other officers. Now, the Commissions Clause also says commission all the officers of the United States. Commission all. See that? Meaning that everything else. The president does not and cannot appoint or commission himself, obviously, and he cannot qualify as an officer of the United States when the Constitution draws a clear distinction between officers of the United States and the president who appoints and commissions them. Similarly, the Impeachment Clause. It also shows the president is not an officer of the United States. It says, look at the distinguish this. The president, the vice president, and all civil officers of the United States shall be removed on impeachment, high crimes, and misdemeanors. See how that's separated out? That's not what we saw up here. They could have put and inserted right into this president and vice president, but they did not do that. In fact, they removed them. Now, there is no need to separately list the president and the vice president as targets of impeachment if they are also civil officers. If this is the same as this, then why do we need these things? You don't, because they're not the same. That's why they included it there and not in the other one. Now, they say this is explained by Justice Story. The enumeration of the president and the vice president as impeachable officers was indispensable. The Impeachment Clause does not even affect to consider them officers of the United States. Other clauses of the Constitution would seem to favor the same result, particularly the clause respecting the appointment of officers of the United States by the executive, the president, who is to commission all the officers of the United States. Now, the precedent of this course confirms this as well. We've got some other cases, in 2010, courts had some more case law. This court interpreted the phrase officers of the United States that extends to those appointed by the president, not the president himself. Now then, there's also the fact that Section 3 applies only to those who took an oath to support the Constitution. That's the oath required by Article 6, saying senators and representatives before mentioned and the members of the several state legislatures shall be bound by the oath or affirmation to support the Constitution. But that's not what the president does. The president promises to preserve, protect, and defend the Constitution, and the word support is nowhere to be found in there. So the Colorado Supreme Court didn't explain that. Well, how do you explain that oath versus the promise? And it entirely ignored Trump's argument. Didn't even explain it, just skipped over that. Well, that fact is very inconvenient for us, so we don't want to talk about that. They said that the normal and ordinary usage of the term officer also includes the president. Well, it's like close enough. Same thing that they're doing with E. Jean Carroll. Yes, we have the R word and the assault word, but we're just going to bundle it all up into the R word because we lost on the R word. So that is simply false. They say every time this phrase appears in the Appointments Clause, the Commissions Clause, the Impeachment Clause, 3 different locations there, they say it excludes the president and refers only to the appointed and the commissioned officers officers rather than the elected officials. No president in there in any of them. Now, the Colorado Supreme Court noted that Federalist number 69, it describes the president as an officer elected by the people, and that Andrew Johnson once described himself as the chief executive officer of the United States. But none of that has any bearing on whether the president is actually an officer of the United States, as the phrase is used in the Constitution. The Colorado Supreme Court also cited a draft law review article, not even published apparently, to support its claim that Section 3's drafters and their contemporaries did understood him as an officer, but that article cites nothing and purports to the Constitution's use of the phrase. Colorado Supreme Court also noted that the president is an officer in the ordinary meaning, and they claimed that Trump conceded that point in the colloquial sense, but the Constitution makes clear that one can be a lowercase officer without being an officer of the United States, by the way. Article 1 requires the House and the Senate to choose their officers, but these legislative officers are not officers of the United States. So in other words, the word officer is thrown around like even more loosely in other places in the Constitution. So the same goes for the Colorado Supreme Court. They say that the presidency qualifies as an office. No, they say, well, okay, it's obviously like an office, like it's a building that has offices in it, but whether the phrase office, because everyone could essentially be under the office of the United States, right? If it's just a broad category that's meaningless, then why didn't they just say office of the United States? Just put them all in there. And they say canons of constructions also support our interpretation here. Now, when Section 3 lists the officials and the positions, it does not mention the president. It does not mention the presidency at any point. It also lists the covered individuals in descending order, right? So it's most powerful to least, the highest federal officials and going down. Then it has a catch-all phrase, any office, civil, military, and so on. And so if we're accepting Colorado's assertion that that includes the presidency, well, then one must include and conclude that the drafters decided to bury the most visible and prominent national office catch-all in this phrase, any office. Just, yeah, presidency too. This reading defies common sense. Nobody thought that that's what it meant when they drafted the 14th. In Section 2, they carry on. Trump's defense at the Supreme Court, they say, all right, SCOTUS, the court should also reverse because nothing that Trump ever did in 2020 in response to the election even remotely qualifies as an insurrection. No prosecutor, not even deranged thug Jack Smith, has attempted to charge President Trump with insurrection. There is a U.S. statute for this, 28 U.S. Code 2383. It's right there. Charge someone. Jack, in the 3 years, not a single person, despite the relentless and ongoing investigations of President Trump. And for one good reason. Why? President Trump's words that day specifically called for peaceful and patriotic protest and respect for the law and for order. Saying in his speech at the Ellipse, President Trump told the crowd to peacefully and patriotically make your voices heard. Trump said, I encourage support for our Capitol Police and our law enforcement. And on the evening of January 5th, President Trump even instructed the Secretary of Defense, who had authority to deploy the National Guard, he said, do what's required to protect the American people. What a great president. It's going to be nice to have him back, isn't it? Now, Trump never told his supporters to enter the Capitol, and he did not lead, direct, or encourage any of these unlawful acts that occurred. Now, either in his speech at the Ellipse or in his statements. Now, Trump also sent tweets throughout the day saying, remain peaceful, stay peaceful. He told the crowd to go home now. But the Colorado Supreme Court instead faulted Trump for, in its view, failing to respond with the alacrity when he learned it had been breached. They wanted Trump, I guess, to just start live streaming, like pulling his hair out, lighting things on fire. I'm so nervous, crying or whatever. I don't know what they wanted. They did the same thing with George Bush. Remember, they were criticizing him. They're like, well, he sat there in front of those kindergartners for 5 minutes. What an idiot. He wanted it to happen. You're like, can you relax for 2 seconds? It's Congress. That's their prerogative, by the way. That's their jurisdiction. What's Trump going to do? Send in the National Guard? And he tried to do that on January 5th. Mayor Bowser sent a letter back to him saying, we don't want your support. And they called him somebody who was going to try to take over the Capitol for wanting to bring troops in to secure the Capitol, right? So he's damned if he does, damned if he doesn't. So Trump didn't respond like a hysterical lunatic like Liz Cheney was supposed to. A failure to act, even if that's true, doesn't constitute engagement in an insurrection. Engage carries the idea of active rather than passive conduct, voluntary action, calling for peace, calling for patriotism, respect for the law and order, and directing the Secretary of Defense to do what needs to be done is not leading an insurrection. But Colorado held the events were an insurrection. Why? Because a large group of people forcibly entered the Capitol, which was orchestrated by Ray Epps, who got probation, by the way. He showed up on the FBI's most wanted list, but I guess not that wanted. The mob was armed with a wide array of weapons, which were what? Flags with pointy ends on them. There were like 2 guns there, if that. The mob stole objects from the Capitol premises. Wow. Yeah, like the podium. Yeah. Which I think was going to be control of the country. And they repeatedly and violently assaulted police officers. Yes, so did Ray Epps, shoving signs into cups. But Trump did not engage in any of those activities. No. And none of the president actions from Trump were anywhere close to an insurrection. Raising concerns about the integrity about elections is the job of the executive branch. He's supposed to look into fraud and irregularity. Giving a passionate speech that says fight like hell, metaphorically speaking, is not an insurrection either. And by the way, the 14th Amendment in Section 3 is not a vicarious liability crime, meaning that I'm not guilty for someone else's conduct. There's no legal basis for imputing the conduct of others to Trump. The Anderson litigants instead must show that Trump's own conduct, and not the conduct of anyone else, is actually an insurrection. But no, they insist that Trump's speech, his words, and his statements leading up to the events constitutes acts of insurrection. Because this sociology professor, called Professor Seeming, he said Trump was speaking in coded words, and he can interpret them because he can talk to extremists. Both the district court and the state Supreme Court relied heavily on his coded language testimony. It's like the MAGA whisperer. Neat. But this court should not allow a candidate's eligibility for the presidency to be determined by a coded messages sociology professor from some school. This court cannot tolerate a regime that allows the entire state's electoral governance to be dictated by Sociology 101. Now, finally, President Trump's speech at the Ellipse and his post-election tweets do not remotely constitute incitement under Brandenburg versus Ohio. First, Trump's statements cannot be punished under Brandenburg unless they were directed at inciting or producing lawless imminent action, which they weren't, and that they were likely to incite and produce that action. Now, the Brandenburg standard does not turn on whether violence actually occurs. It turns on whether it was intended and likely to incite the violence. Now, and the constitutional status of Trump's statements would be no different if he had given the same speech and his supporters remained entirely peaceful as he urged. This court would never tolerate criminal prosecution of his speaker who told his audience to fight like hell and take our country back, because that is political discourse. It's very common. And because Trump did not incite violence, under Brandenburg, it's free speech, and he did not engage in insurrection. This is amazing. Nor can Professor Seemy's code-breaking abilities. He's like a cryptographer, you know, probably has spreadsheets of coded language from MAGA. What does 1776 mean, Professor? Are we under attack? He's going to transform core political speech into proscribable speech. You're not allowed to say that, or else you're a right-winger. Now, the words uttered by President Trump on January 6th would be regarded as entirely benign if they'd come from anyone else who's not Trump. But this guy, goofball, he said that the courts, they had a Trump-specific version of the First Amendment because he's so dangerous. He says Trump speaks in coded language, but intent becomes relevant under the First Amendment, and they just imputed to him nefarious motives. An inquiry to the speaker's intent can never be transformed from a constitutionally protected speech into unprotected speech just because a sociology professor says so. They say, look, SCOTUS, as we wrap this up, let's be clear. Section 3 should only be enforced by Congress and whatever they choose. Enforcement should not go to state officials like Crazy Eyes Griswold. Congress enacted enforcement that required prosecutors to do certain things, and the Insurrection Act also provides that if you're convicted of engaging in insurrection, then that matters. But Congress has also since repealed the quo warranto provisions from the 1870 Enforcement Acts, but the Insurrection Clause remains. So they say we should follow this pattern. A presidential candidate's eligibility for office should not be resolved by having state trial courts evaluate opinion testimony from a sociology professor and copy factual findings from a hearsay-filled and partisan congressional committee report, and then courts demand that they defer to their facts. It's all just fake. I mean, great paragraph there. So they say the court should reverse. Section 3 can't be used to throw Trump out of here. By the way, it's only from holding office, not running for office. So if he wins, then you can sue us. But it says no person shall be a senator or representative. And even if they say president, or look, the elector of president. Now, there's also good argument from Edwin Meese that the safeguard, like the reason why we don't have presidency in here, is because electors also provide a safeguard on this, because the electors are essentially prohibited. So it does not prevent anyone from running for office or from being elected to office, because Congress can remove that, right? So even if they say it did apply, Trump could run, win, and then Congress could remove it. Congress may, by a vote of 2/3 of each house, remove the disability. Congress has done so on many occasions. They give us a long list of these. Disabilities are removed. The men who were voted filled their several localities, and they even filled important offices. So the existence of the disability removal provisions shows that it's Congress that ultimately decides whether someone can be seated or not. Now, the Colorado Supreme Court did not go so far as to hold that Section 3 bans Trump from appearing on the ballot, although there was some language in its opinion that gestures towards that idea. Instead, it held that only qualified candidates can appear. And so they basically created a new qualification. Now, this prior case says that they're powerless. They can't do that. They created a new qualification out of thin air. And so their case violates that by prescribing a new qualification for the presidency. It requires that a president be qualified under Section 3, not only on the dates that he holds office, but on the dates that he's running for office. Constitution doesn't say that at all. Interesting argument. So they created something new. It says holding, not running. And that's a new requirement. Supreme Court precedent says can't do that. That's a nice technicality there. Now, this is no different from a state enforcing another residency requirement. Just pick any other requirement. No person shall be elected. When elected, be an inhabitant of a state. They say there were other provisions as well. So a lot more meat on that section. As you see here, Colorado Supreme Court also violated the electors clause, is what they say. The Colorado state legislature allows the judiciary to intervene in ballot disputes only when charged with a duty, and this bars Trump from holding the office. So the Colorado Supreme Court, instead, they tried to concoct a wrongful act. They made it up. They claimed Secretary Griswold would violate the law, a provision of the state election law, but she's not going to violate anything. She just took that on her own accord. So the Anderson litigants were wrong. Trump didn't forfeit any of his claims here. The courts precluded him from making them. Colorado is what its statutes say, and so these cannot be flouted. And so respectfully, they say the judgment of the Colorado Supreme Court should be reversed. All right. So interesting filing here, 59-pager from Donald Trump landing up at the Supreme Court. A lot of technical stuff in there, and I think we spent a lot of time on the procedural history, but really hitting the meat and potatoes of a lot of the same stuff we've heard before. And we'll see if there's anything that the Supreme Court likes and latches onto there. As I'm reading that, I'm thinking, okay, are they writing for any particular judges? What judge is going to latch onto what arguments? And how are they going to resolve this? Are they going to resolve it on a technicality type of a thing? Well, you know, he's technically not holding. Like, if they buy that argument, I don't actually like that argument, because if they say, well, Trump cannot be precluded from holding office, so he's on the ballot, then when he wins, they're just going to be a bunch of challenges saying, well, now he's disqualified under the insurrection clause. And are they going to have to revisit that whole thing? I don't know. We'll see. So that is what Trump and his team submitted. Now, Crazy Eyes Griswold, Jenna from Colorado, who we just heard and learned a little bit about here, she showed up to talk with Anderson Cooper. And so we're going to listen to her in a minute and see what she says before rolling over to Trump to hear how he anticipates this going at the Supreme Court. Now, this is Crazy Eyes Griswold here talking with Anderson, and Anderson actually has some questions for her, saying, you know, this might actually cause some chaos. President Trump might be right.
Senior legal analyst and former federal prosecutor Ellie Honig, and joining us is Colorado Secretary of State Jenna Griswold. So, Madam Secretary, I'm wondering what you make of the filing by the former president's legal team, particularly the argument that removing him from the ballot would unleash chaos and bedlam.
Well, I think it's really interesting they chose to use that language, because it's just more of Donald Trump saying that if he's not in charge, the country's doomed. But the language itself, on top of that, I hope is not a threat to the stability of our country. Donald Trump has used his words to incite violence on January 6th with the insurrection, and violence to election workers, judges, anybody who stands up to him and stands up for our democratic institutions. I think it's just more of the same, and it underlines how dangerous he is to the country.
Wouldn't it be chaotic, though? I mean, if voters in your state, any other state, Maine, felt that they were disenfranchised?
Yeah, Anderson, it would.
Whether or not it's violent or not, but it's just certainly chaotic, no?
50 states doing 50 things.
Well, he used two words in that description, not just chaotic. And
Bedlam.
Anderson, you know, at
Bedlam.
the end of the day, it's my job and all secretaries of state job to uphold the law in the United States Constitution. There is clear language in Section 3 of the 14th Amendment about when elected officials or anybody who swears to uphold the Constitution engage in insurrection. It would be equally chaotic to not uphold the Constitution in this case.
You can just let the people vote rather than deciding that you're going to change the law and say that he can't even run for office now and then have 4 Democrats throw him off. You could just let the people of Colorado vote. If they think he's an insurrectionist, well, then they could go vote for him, because we already had a mechanism by which we tried to prosecute Trump. Remember, politically, they impeached him for the insurrection. That was the charge. And then he was acquitted on that in the Senate. And that's a representative process for the country. Okay, we actually have representatives. People vote for the representatives who go to the House. People who vote for the representatives who go to the Senate, and they get to decide. But the judges are not. And I don't know how things work in Colorado. I don't know if she runs or if she's appointed or if she's accountable to the people, but the judges are judges. That's not part of the representative body. So it's anti-democratic as can be, but they don't care, because this is their only play. They're afraid they're going to lose lose to Trump?
There's lots of legal arguments.
Ellie, how do you see it? I mean, what are the odds that the Supreme Court will actually go with the president's brief?
I think the Supreme Court is going to agree with Donald Trump. I think they will strike down
Shout
what
out.
Colorado has done here.
Nice job,
Donald Trump
Ellie.
makes two categories of arguments. One of them is factual. He says, I did not engage in insurrection. I don't know how compelling that is when you look at the facts. I don't think the Supreme Court's going to touch.
It's very compelling because nobody's charged him with that at all.
I do think Donald Trump his lawyers make some powerful legal and procedural arguments. For example, and Secretary Griswold mentioned the text of the 14th Amendment. Well, the 14th Amendment, Section 5, says Congress, the U.S. Congress, shall pass legislation to enforce this. It does not say Congress or the states, if they so choose. If I can ask Secretary Griswold, I'm curious what your view is, Madam Secretary, about that. The fact that Section 5 says Congress shall pass legislation, it doesn't say anything about the states.
Good question. Go ahead.
Section 3 also specifically talks about the role of Congress. And the role of Congress in Section 3, which is the provision we're talking about, is Congress can determine that someone can be seated for office even if they did engage in insurrection by a certain amount of vote. So that is the clear language.
2/3.
On top of that, the historical record of this provision is that Section 3 of the 14th Amendment is self-executing.
She didn't answer
meaning that Congress does not and did not have to pass legislation.
No.
It has been used throughout American history without.
Ellie knows. Look at this. Look at his face. He's like, this woman is blowing so much friggin' smoke up my derriere right now. This is not good.
Congress first passing a law enabling it. So I do think that is an incorrect argument.
But who is the self in self-executing? Who actually enforces this?
Me.
Who makes the decision?
I do. I'm Jenna. I'm me.
Well, under the electors clause, it's the states. It's up to individual states to
Just
determine how to decide who they're going for president. That's why we have different elections in every single state. That's also why I think the Colorado Supreme Court got it right in Colorado. To your point, it's pretty evident that Trump engaged in insurrection. But on top of that,
why didn't they charge him? Why has Jack Smith charged him with everything else but not that, huh?
I would say Section 3 of the 14th Amendment is clear, and other clauses in the Constitution let states determine how to execute elections. That's exactly what's happening in this case.
I want to play, Madam Secretary, something that one of the former president's attorneys said on Fox earlier this month about what would happen if the Supreme Court were to take up the case.
I haven't seen this. Let's see. Oh,
I think it should be a slam dunk in the Supreme Court. I have faith in them. You know, people like Kavanaugh, who the president fought for, who the president went through hell to get into place. He'll step up. Those people will step up, not because they're pro-Trump, but because they're pro-law, because they're pro-fairness. And the law on this is very clear.
Yeah, that sounds fair.
I'm wondering how you interpret that, because on the one hand, she's indicating that Kavanaugh would step up because the former president went to bat for him, but then she quickly corrects herself and say, well, he wouldn't step up because of that. It would be because he cares about the law.
Well, the answer is that Trump fought to get good people on the court who like to follow the law and follow the Constitution, and they're not partisan hacks. And they tried to do the same scam garbage with Kavanaugh. Remember the Blasey Ford stuff? How you got attacked in high school? 35 years, however long ago that was, 25 years ago. Same E. Jean Carroll garbage. Same thing. So the point is, Trump is putting people on who are better than their side, and so they're not going to fall for this political garbage. That's all the point that Alina was making.
I just think it's so reckless of his attorney to have said that, let alone even thought it. It undermines the independence or the perceived independence of the court. But I think the bigger picture is that this is how Donald Trump operates. He wants people around him to be loyal only to him. He wants them to set aside the law, the Constitution, even so far as saying that if he would assassinate a political opponent, he wouldn't face liability. That's one of the reasons
That is not the argument. The argument is that you have to be impeached and convicted before you're exposed to criminal liability for things that are within the outer perimeter of your presidential responsibilities. But do you see? They don't even... Okay, assassination. Got it. Yeah, you're very sane.
I do think he is extremely dangerous. And I think ultimately it is very likely that the American people will have a huge role in saving our democracy in the general election and not waiting for the Supreme Court to solve the big problem of democracy that we have in this nation.
Madam Secretary, I appreciate Ellie Honig as well. Tonight's other...
Okay, so it says that the Colorado Secretary of State, from their website, the mission is to ensure the integrity of elections. Okay, that's what they're doing. So she's going to be there to ensure the integrity of the Colorado election. She is the person running the elections. So it really doesn't matter if Trump is on the ballot or not. Can you imagine what's going to be happening in her office with all of the people who work for her that all have the same deluded mindset that Trump is an insurrectionist who's going to wreck the country? Look at her smile. She's whacked. So they're all going to be in cahoots, right? You know, the idea that anything, she said that anything coming out of Alina Abba's mouth is problematic. It's like, could you trust anything that comes out of her office? Nothing, because she is a weaponized partisan secretary military hack. Now, Trump is responding, and she's got the craziest eyes we've seen here. So here's Donald Trump responding to some of this. He showed up on that network and talked to this guy, and here is what he said about the Supreme Court and the people there who are going to be ruling soon.
You have some other great justices up there, and they're not going to take the vote away from the people. I mean, right now, you saw in the history of the Iowa primary, I mean, the history of it, goes back a long time. I won by the most. Nobody's ever won, as you know, because you covered it very well, but everybody covered it. Even the bad reporters covered it this way. There's nobody even close. I doubled up and more than doubled up the second best, now the second best. It stood for a long time, as you know, that record. But they want to make sure, I'm sure the Supreme Court is going to say, we're not going to take the vote away from the people. Now, Biden is a threat to democracy. He's an absolute threat to democracy. He's very dangerous for a couple of reasons. Number one, he's grossly incompetent, which is the number one reason. But he's also, actually, in his own way, it's not him. It's the people that surround him. You got some very bad people surrounding him at that desk. You have people running the Department of Justice surrounding him. They're young and they're smart and they're communists and they're Marxists, they're fascists, and they're running this country. They're running it right into the ground. But I don't think the Supreme Court would do it because you can't take the vote. You know, I'm leading in every poll. I'm leading Biden, but I'm leading the remaining Republicans. There's two of them and they're barely hanging on. How can you possibly take the vote away?
Well, because they know that. They know that they're losing, and it is their tactic now. 4 different indictments, multiple fake assault cases from 25, 30 years ago from people like E. Jean Carroll, who were incentivized to run by having the whole thing funded by guys like Reid Hoffman, sold on the idea by guys like George Conway. The whole story, right? It's all concocted garbage by political opposition, and Trump is responding to it. Now, we're going to be here, my friends, continuing to cover this and more. We're awaiting the Supreme Court to have oral arguments on this, to hear additional filings coming in. We're going to wait for their response and their ruling, because if this comes back down and they say that, yeah, the various states can just decide, if you got to have people like this just disenfranchise the entire state of Colorado, well, that's going to not bode well for the country, in my humble opinion. And so we're excited to see what happens here. Hopefully the Supreme Court shakes some sense into these people. We'll be here continuing to cover it. Thank you for subscribing as we do. Don't forget to check out robertgovea.com. The link is down in the description below. If you want to read the PDF, we upload all of our PDFs there. We've also got a great newsletter where we synthesize all of our show segments, bundle them up, send them right to your inbox, and that way you never miss a thing. So check it out, robertgovea.com. Link is in the description. We'll look forward to seeing you there and back here on the next one.